Bienvenidos a un nuevo episodio de ASIPIPodcast denominado Artificial Intelligence Regulation, Regulación de la Inteligencia Artificial.
Welcome to a new episode of the ASIPIPodcast, this time organized by the Technology and Artificial Intelligence Committee. My name is Nicole Pérez, founder of Inteligencia in Panama, and I have the honor of serving as your moderator for today's discussion. We are delighted to be joined by one of the leading academic voices at the intersection of artificial intelligence, innovation, and intellectual property law. Our guest is Professor Noam Shemtov, Professor of Intellectual Property and Technology Law at Queen Mary University of London, where he also serves as Deputy Director of the Center of Commercial Law Studies. Professor Shemtov works focused on the legal and policy challenges raised by emerging technologies, particularly artificial intelligence, data-driven innovation, and their impact on intellectual property systems. His research and teaching have significantly shaped academic debate and policy discussion in the rapidly evolving field, and on a personal note, he was one of my favorite professors during my LLM studies. Today's episode will explore how AI is reshaping IP landscape with a special focus on AI regulation in the United Kingdom and the European Union. Professor Shemtov, welcome, and on behalf of ASIPI, thank you very much for accepting this invitation. To begin with, I would like to highlight that the UK, for me, has been something of a pioneer in AI regulation, particularly with its recognition of authorship for those who make the necessary arrangement for computer-generated works as established in the Copyright, Designs, and Patent Acts of 1988, even when AI wasn't in the scope of the daily conversation. Before diving into the specifics of UK regulation, Professor, I want to start by asking you to share us with some of the preliminary consideration regarding the distinction between AI-assisted works and AI-generated works and/or inventions. Professor, you have the mic.
Thank you. Thank you, Nicole. And first of all, thanks very much for a very kind introduction. One correction, I'm the director of the Intellectual Property Research Institute at Queen Mary, rather than the deputy for CCLS, so that has changed. In the meantime, I also plug into the discussion here IPIN, where I serve is the president, which is the European Intellectual Property Network of Scholars. Now, and of course, I would like to extend my thanks to ASIPI as a whole for the opportunity to speak to your audience and to Christina as part of that, the president of the technology section, I believe. So let's begin. It's interesting that you chose to focus at the beginning on the UK, because the UK is presently considering its next move. Less so in relation to AI outputs. We can discuss AI outputs in a minute, but what is happening right now is that a few months ago, the UK government put out a consultation, an invitation for a consultation, when they asked for comments from the public, they request comments from the public and from stakeholders in relation to the state of copyright law, among other things, regarding AI technologies, the availability of AI tools, and so on, where the main focus, although the output and protectability of output is of course one of the issues, but the main focus is on the training side of things. So where exactly should we position ourselves here in the UK in relation to the training of AI model on the basis of a copyright protected content. When it comes to output, I think you kind of hit the nail on the head when you said, how can we differentiate between AI-assisted works and AI-generated works, in the end of the day, both are not legal terms. The first suggests some kind of a co-authorship process with the human, so AI assisted. So the AI just assists me, but it is me, or it is I, who is actually the driver or the originator of the work, while in the case of AI generated, to an extent, this terminology suggests a removal to a large extent of the human agent from the process, and have something where the AI is indeed at the driver's seat, with perhaps the human just initiate the process or yeah. Now, my personal view is that when it comes to outputs, copyright law as it stands today is rather fit for purpose. So, and I think it will take time to courts to develop the right jurisprudence in that respect. But if, for example, in Europe, we look at the author's own intellectual creation as the standard for originality, that I believe, and we know that in Europe, the author's own intellectual creation means the exercise of free and creative choices by the author. This standard can be applied with the relevant modifications to processes where AI tools are deployed. And I think that the same applies for, if you look closer to the origin, to the United States, the US Copyright Office published last year very extensive guidelines, part of which deal exactly with this question. They issued a number of decisions. In the meantime, these are not judicial decisions, but these are decisions of the AI office. But I think they're quite indicative to where we are going in that respect. So I think that there, by and large, like every time that we have some new technology being introduced or launched, copyright law settles and would not require. I don't think we require any new additions or revisions of copyright law. I think that when it comes to training, this is where I think policymakers are really faced with a more pressing questions, and this is where perhaps policymaking intervention is likely to be required. Where I understand that it is being. So I think in your region, if I'm not mistaken, there is a bill that is pending before the Brazilian Parliament that deal, among other things, with that question as well. So it's the question of regulating the training process. But we can expand on that if you wish later.
Yes, actually, I was going to ask you if you have some case law that can assist us with respect to the exercise of free choices, and how much human intervention has to be within the works or invention in order to qualify for copyright protection or even patent protection. Is there any kind of case law currently that can assist us in identifying that?
Yeah, so it's interesting that you said patent as well, because we can jump into patents in a bit. So I think that when it comes to outputs, there is a group of cases in the United States rather than in Europe, which you're probably familiar with. But it's interesting. One of the former name of the case, there is the work of art. I think the name was American Grilled Cheese. Where it seems to be, and I think I can see the logic here, or the rationale that the copyright officer, the focus would be, if you think about the creation process via prompts. Okay, so I'm sharing with you my take here. I think it is the initial prompt, which is the one where people have, or judicial bodies or tribunals may have an issue with recognizing the initial prompt as an original contribution by the author's own intellectual creation. Because when I describe, let's say I want to create an image, if I describe something in text, I know what I want to get, kind of, right? I know the ballpark I want to land, where I want to land, but I don't know exactly what is going to be produced. So here, the distance between my ideas and my concepts and the output is quite large. I think once the original prompt is made and the original picture or image is created, then I think it is, you are using prompts in a way like you're using a brush. You would say, okay, remove the blue background to the white background, create larger lips. So this is where you're starting to play with it. So I think that, and you can kind of recognize that to an extent, although not explicitly approached in that way. When you look at some of those decisions of the American Copyright Office, you see that the distance between the image that was created in response to the original prompt and the final product, if the distance test is quite large, so I added on top of it a lot by continuing to prompt, then they would be prepared to recognize originality for the purpose of copyright. But if I'm feeding my AI tool with an initial prompt, do me 1, 2, 3, 4, and it creates something. And this is more or less what I also propose as the final product. This is not likely to be recognized as original for the purpose of copyright law, because there is a distinction that was made in the United States in some instances between instructions and suggestions. You do not instruct per se an AI model because you don't know exactly what you suggest, and you know more or less what you want to get. So, and that is particularly the case in relation to the first one. Once you do the first one and you start to move in small stages, this is where I can actually say, this is mine. Sure, I didn't use a brush to do the yellow, but I asked him, add the yellow, remove the leaves, enlarge this, So, and I think courts would need some time in order to get accustomed to that. But by and large, the present tests are sufficient. When it comes to patents, I mean, this is an area that I was involved in quite heavily. I think to date, the only a study that was commissioned by the European Patent Office on the question of inventorship and AI is something that I wrote about 7 years ago. So when it was still it's kind of at its infancy. The area, and I did that before the flurry of applications, the DABUS applications that you may be familiar with. So the DABUS applications, these were patent applications that were really designed to stress test the patent system when it comes to inventorship. They were filed all over the world in order to see what does patent law have to say about the patent application where the inventor, the designated inventor, is AI, rather than a human, a natural person. And I thought that those would be rejected, and in that they proved that they would be. It proved correct. And I also thought that there is no need to change. I was under the view that there is no need to change patent law, at least for the foreseeable future. And I think that to a large extent, the discussion today regarding the changing of patent law has been put on ice, because the patent law as it stands is well equipped to deal with invention-making processes where AI tools are playing a significant role, but nevertheless, you have the person who prompts, steers, have the concept of what is that they wish to achieve, and steer the AI tools in the way that they choose to steer them in order to reach the invention.
I think it's very interesting what you have shared with us, with especially interest in the use of prompts and the process of suggesting and changing what AI has to us as an output. Personally, for me, it has very sense, because in sort of a way, you are constructing or making an expression of the idea that you have, but instead of using, as you mentioned, a brush or maybe a computer, if you are writing a book or something else, you are just using a program to have that final purposes. However, with regarding to patent law, and I want to enter into that area as well. This brings me, AI regulation brings to me as a reminder, and it also was my thesis in law school. All the conversation and dispute that arises when we were discussing about software protection, whether if copyright, whether if patents or sui generis system. We know right now that there are some kind of things that we can patent, and there are other things that are protected throughout copyright law. For me, in my personal opinion, it has to be a sui generis one, and that's what I stand for until the date. But what do you think regarding AI discussions and patent discussion as well in the field of AI? Are we still covered with the current regulations that we have, or we need to make a change and start to explore a little bit more regarding the protection of those creations or inventions throughout AI?
Okay, wow, that is a very wide question. So I'll try to pick it, each part at a time. So, by the way, just going incidentally to the point that you were saying about software being protected better, well, preferably be protected to a sui generis right. So, as you may know, you are in a very distinguished club in the sense, although there is no debate anymore. So this train has left the station a long time ago. But in the early 90s, there were a group of probably the most eminent or distinguished IP scholars in the United States, Jerry Reitman and Pamela Samuelson, and they wrote what is known today as the Manifesto for the Protection of Software, where they said essentially what you're saying, no branch of IP law really fit this product. It would be better to have something new. I think for practical reasons, we chose one of the existing ones. I mean, we know the old saying, right? They don't let the perfect be the enemy of the good. So you continue with what is practical, lower hanging fruit, and I think that is the choice that was made by policymakers around the world. But going on to the question of AI and patent law, I think it's important to discuss, to distinguish or to separate the discussion to two completely different and independent questions, but totally different. One is questions of predictability of inventions in the process of the making of which AI tools were used. That is one question. The other, which I think you may have also referred to, correct me if I'm wrong, and it's separate, it's the predictability of AI technology as such for the purpose of patent protection. Now, those are completely separate questions. The latter one, so the predictability of AI technology as such, is a question that pertains to the predictability of software, right? So AI today, and rightly so, AI technology is looked as most places around the world and in most contexts as a subset of computer implemented inventions or software related inventions. The first one, which is the predictability of inventions in the process of which AI was used, may have nothing to do with software. So, for example, I can make a new invention in the field of pharma. So, discover a new drug for treating medical condition X. But the manner in which I arrive to the conclusion that it is this drug that would be most suitable to treat condition X was by using AI tools that actually are being used as we speak in drug discovery processes and so on. simulation methods that are being run. So it cuts time, it cuts effort, it makes the research also more concrete and accurate. So these are two separate questions, and they give rise to different considerations. Nevertheless, I think that in both cases, by and large, patent law is well equipped to deal with. So I'll give you an example. If we start with the first point that you raised, so that is, say, the adequacy of patent law to deal with, so the adequacy of patent law in dealing with inventions in the process of which AI tools were used. So the first question is the one that I was referring to earlier, the question of inventorship. And there are some issues in the United States, but you asked me to focus on Europe, so I will. For example, there was a decision about a year and a half ago by the highest German court, by the German Federal Court, that dealt with the final appeal for this Davis decision. And the German court appeared to suggest that as long as you have a human in the process, right, that made the whole thing so... let's leave the precise legal terminology, but it made the whole thing possible by contributing, basically contributing not by just putting money down, but by being responsible for the process where the technological leap was by and large done because or due to the AI. Nevertheless, as long as you have a human in the process that makes that process happen, you have your inventor, and you don't have any questions about inventorship. Now you may ask, well, you know what, if that is the case, okay, but how do we assess, for example, inventive step when it comes to how do we benchmark it? Because if we ask, is it obvious to Noam, now without AI, so for sure, without AI, a lot of those things would not be obvious to me. But if I have AI, it becomes fairly standard. But I think that today we have this recognition that when we are asking those questions, what a court would do is to ask, is that a sector where AI is being used regularly? So a skilled person in the research process? If the answer is yes, then what you are asking is really, is it obvious to the person skilled in the art, equipped with the kind of AI tools that exist in the industry? Not always easy to identify the benchmark, but this is conceptually the question that you ask. So we have it there. It's the same kind of questions. It's like if you ask, is it obvious to the person skilled in the art in some areas? It would be obvious to the person skilled in the art equipped with, say, a sophisticated type of microscope, right? So the same thing. It's just going to take some time for the courts and for patent offices to figure out which sectors may be using which types of AI tools under which circumstances. That's not always easy to ascertain. It will take some time, but I think we'll get there. Going to the second point, and that is AI as a subject matter for patent protection. Here, I think you have more of an issue. But again, it's not a new issue, because when you think about AI inventions, it's helpful to think about it as two categories of inventions. Applied AI innovation, right? And core AI innovation. Applied AI is when I take AI technology and I incorporate it, say, into, let's say I invent a new type of X-ray machine, where various parameters are being decided by AI technology that I embed in the X-ray machine, and as a result of that, the X-ray machine is just better. It's better in doing whatever it is that it's doing. So let's apply AI, and here I think you have less of an issue to get your patent if it's new. The issue is what we call core AI innovation, and this is AI technology at its core, where in many jurisdictions, and I suspect in most of South America, patent offices are likely to view it as mathematics, because at its heart, this is. I mean, what is an AI model? It's not a model. It's not something physical that I can touch. it is software. It's algorithmic arrangements, and it's mathematics. And this is where you are more likely to face some issues in compatibility right now.
Okay, Professor, many thanks for that intervention with the two questions. I think it's pretty clear the problems that we will have with AI, and that AI regulation is still developing. I think we have to wait some years to have more case law that can help us or assist us regarding the protection and even the enforcement of AI innovations or AI generated innovations. However, as the final questions, because we know that we have some time cap, I want to know about currently the part of enforcement and infringement within the UK and the EU regarding AI works and even AI innovation. Is there any case law or orientation regarding that standpoint?
Mm-hmm. Actually, there is. It is in the field. So we have something rather fresh. Both decisions. So I'll give you two examples from the UK and from Germany. Both of them from last November. Okay. So just a couple of months old. Both of them, or the two of them, have, to an extent, contrasting outcomes. And I'll explain. Both decisions have to do with AI models that were trained on the basis of copyright-protected material. I think that a number of things, I mean, we don't have time to delve into them or to dive into them in great detail, but there's a number of things which are worth flagging up. So, for example, in the United Kingdom right now, so we're going to pretty obviously change the law here in relation to training. So this is what I was referring to at the beginning. This is what policymakers are considering, the government is considering right now, and I'm taking part in various roundtable discussions, which are part of this process. But right now, before the change, the law appears to be quite favorable to the creative industries, because what it tells you is that there is one slight exception, which is if you use copyright protected works for training for for research non-profit purposes, then you're fine. Anything else, you're not. There's no exception. So it means you need to go to the owner of the copyright in the work and ask for permission. That is in relation to any copy that is made as part of the training process. You have those temporary copies. However, when Getty Images brought an action in the UK against Stability AI, they failed. I mean, they won on a small trademark-related issue, which is less relevant. They failed because the thing with training and with copyright is that copyright is territorial. So if I'm doing something, so if I'm going to a jurisdiction which is very friendly in terms of its policies, I do my training there. I then take the model after it was trained and offer it to the UK public. And also when I trained, of course, I trained it on the basis of works of authors, which are UK authors. Nevertheless, if I did it in another country, I probably carried out all the copyright relevant activities in another country. Now, I need to be judged by the rules of this country if this country chooses to do so. But in the UK, so the court here had little to say about that. Getty tried another argument, and I'm mentioning that because that was relevant for the German decision. Getty tried another argument, and Getty said, you know what, forget any copies that were made there. The model itself is an infringement, because the model you actually bring to the UK, you distribute it or you make it available in the UK, is an infringement. That argument failed, in my view, maybe we can have another podcast on that. Getty could have done better in terms of putting forward their arguments. They considered some points too early or unnecessarily. They accepted, because the way a model works is that once you train it, it is true, it doesn't store the digital files of those works. So in that sense, you don't have a copy in a traditional sense. But a copy is not a computer science, and that would be my argument. And I made this argument about a year and a half ago in a paper that I published with a number of colleagues from the United States. The name of the paper is The Heart of the Matter. A copy is not a computer science concept, it's a legal concept. And as a legal concept, if it has certain characteristics, it is more likely that we can consider it as a copy. And this is what the German court in the GEMA is the German Collecting Society for music, and they sued OpenAI. And there, irrespective of any exceptions for training, GEMA argued successfully, although it's now on appeal, GEMA argued successfully that leaving the training aside, post-training, the model contains copies of these works, even though it doesn't have digital files stored within it. It has various probabilistic, coming from the area of statistics, probabilistic parameters, but they capture the essence and the content of the work. And as evidence, they said, look, I can work it backwards to the original and produce the original, right? So that was successful. And I think this is where we need to keep our eyes open in terms of judicial developments, in terms of cases. Will we have more and more readiness from courts around the world to accept that after training, actually contains copies being a legal concept, not a computer science type of terminology of whether we do or we don't have a digital file in a traditional sense. So I think this is a very interesting area to follow, and I'll be surprised if sooner or later you won't start having these kind of discussions and perhaps disputes in South America.
Professor, many thanks for all your knowledge. I think that we are going to continue to see some challenges in AI regulation and application in judicial cases, especially because it is constantly evolving from the first day that this was like the topic to talk about, and right now, like 4 or 5 years later that everyone started talking about AI, I think that everything has changed quite a lot, and every day we have new issues, and AI is evolving very quickly. And as we know, law not evolves as quick as technology. So we are going to see what happened in the judicial cases. I think Europe and the UK are very up to date with this matter, more than Latin America. But I'm sure that Latin America will rely on what is happening in there as well for assuring the application of law for AI. Many thanks to be with us in this podcast. We hope to have you in another podcast or other initiative as well. And I want to see you as well during INTA in London, that I am sure that a lot of members of ASIPI will want to know you as well. So everyone will have the opportunity to discuss with you in that matters and when INTA arrives. Have a good day, and we hope to have you again in the ASIPI podcast.
It was a real pleasure, Nicole, and I'm looking forward to see you and the rest of the ASIPI board in London this May in Inta. Have a great weekend.
Thank you.